Hello everyone! I hope you're all having a good week. My name is Anaid Lopez Serrano and I will be your instructor for this week's lecture on competence to refuse an insanity defense and other mental state defenses. Before starting the lecture, let's start with this week's learning objectives. The first one being, what is an insanity defense? Hopefully by the end of the lecture you will be able to define what insanity defense is. The second and third being Wallem versus United States and Frendick versus United States. Hopefully you're able to distinct between the two cases. The fourth one being reasons for defendant refusal. The last two being helpful media source that will give you a further explanation on what the insanity defense is. And the last one being the discussion question, which hopefully you all find interesting and do research on this topic. So what is the insanity defense? The insanity defense is an affirmative defense. An affirmative defense is a justification for committing the crime. The insanity defense permits individuals not to be held responsible because of their mental state at the time of the crime. The media attached at the end of the presentation will address what constitutes mental conditions. Many of us assume the insanity defense applies to all mental conditions, and this is untrue. Now let's talk about decisional competence. A variant of decisional competence arises when the defense attorney, the prosecution, or the court believes that a defendant may have been insane at the time of the offense, but the defendant does not want to assert such a defense. This means that the defendant is refusing the defense, but requires the capacity to knowingly and voluntarily refuse it. We will be learning about two major cases with different perspectives. The first being Wallem versus United States. Wallem versus United States upholds society's concept of justice. It emphasizes society's interest in avoiding the conviction of a morally blameless person. This means that defendants are unable to refuse the insanity defense because it can't be accused, convicted of wrongdoing because of their mental incapacities. They are not deemed responsible for those acts. Judges in these cases may consider the defendant's interest, but they're not required to convict them. This case, or let's say this perspective, was overturned in the United States versus Marble. There are a few jurisdictions that still follow this approach, but most follow Frendick versus United States, which we will get to shortly. So Frendick versus United States. This is a different perspective from Wallem versus United States. This perspective gives defendants the freedom to make decisions about the course of the proceedings. This means that defendants may object to the insanity defense, meaning that they can refuse the insanity defense. Competency for this is assessed in a similar way as competent to stand trial. This is where decisional competence comes into play. Defendants must have the capacity to knowingly and voluntarily refuse a defense. This means that they 100% have to understand the proceeding, everything that's going on, and accept the crime. The only thing is that this requires an assessment of mental state at the time of the crime to assess if they were mentally well or mentally ill. The only thing with this case is that the judge could consider imposing an insanity defense if their mental condition impairs the defendant's decision making. Being that if the defendant is influenced by their mental condition, the judge may refuse their refusal for the insanity defense. To continue the discussion on Frendick versus United States, the court provided reasons for defendant refusal on the insanity defense. The first one being that it may result in longer periods of confinement versus being convicted. This is to say that the individual has to go to a mental hospital and they spend a longer time period there than they would if they were going to serve their sentence. The second one is that they want to avoid the stigma associated with mental disorders. The third is that they believe there's a better treatment in prison versus being in a mental hospital. Some may worry that they'll lose legal rights just by being associated with the mental health system. This could be you're not capable, or wouldn't necessarily be capable, but you're not able to get your license or get a job after you've served your mental hospital sentence because of the stigma surrounding mental disorders. And the fifth is that they view their crime as a political or religious act. So they committed this crime because of something political or something religious, and they do not think it's because of a mental disorder. As I mentioned in the first couple of slides of the lecture, this week's media source will touch more on the explanation of the insanity defense. A lot of us think that insanity defense applies to all mental conditions, and if someone were to commit a crime, they could easily get away with it. But this is not the truth. This video will explain further in depth what the insanity defense applies to and how it is used in courts. Now, to conclude this week's lecture, I have a discussion question for you all. This question is based on a scenario. The defendant is required to be on medication because of their mental condition. Is this enough ground for competence to refuse the insanity defense? Explain. Remember, when considering your answer, you have to take decisional competence into consideration, and how the defendant is required the capacity to knowingly and voluntarily refuse the defense. Do you guys think the medication side effects will interfere with being competent? There's a couple things to consider when answering this question. Thank you all for listening to this week's lecture on competence to refuse the insanity defense. I hope you all enjoy the rest of your week.